to prevent the injunction, and already the opponent.
Yes, this would need to be but what not and what I'm asking, that you have to
To provide the same. Actually, there was no title disputed here. It was just that they want that injunction on the property which the defendant
order
already.
will be depending on it is this. Can you see that?
Where is it actually?
Okay.
They submitted it actually in the lower court. They provided.
You submitted in the lower court.
Yeah, because the
Yeah,
crowd
where
You
is
have
it?
to sort the certified copy from the
Yes. Before the final argument will try to provide.
yes, yes.
Actually, may I
Yeah.
see? Okay. The defendant complained that they purchased the land from land in the good faith, and the petitioner has failed to prove the title. But the defendant also argued that petitioner had knowledge in the construction, but raised the objection only after a significant investment was already made on the land, which was from above more than 3 months. The construction already started, and the defendant already paid the investment on it. But after that, they have provided the further injunction. I would like to present my main argument. Okay, since the petitioner is seeking injunction, we must aim to show lack of clear title in petitioner and assert their bona fide purchase and argue balance of convenience plus irrefutable laws in their favor. In the section 38 and 41 of the Specific Relief Act 1963, it is an injunction. Injunction is a discretionary remedy, where in the section 41 of subclause H, injunction cannot be granted when an equally efficacious remedy is available. Example, like if the petitioner would have filed for declaration of possession, but here they wanted the injunction, and that means they tried to ask for the injunction to dismiss
You said you purchased in the good faith.
yeah, land in the good faith.
How? From where you get that good faith? Have you verified any documents, or have you verified in the mandal office or somewhere revenue department? How you verified without verified somewhere? How you get that good faith?
Actually, the defendant purchased the land. One of the defendant purchased the land in good faith because they wanted to. They were all right.
And what is good faith?
Good faith means they want to try to help the social
Huh?
equity of the.
You purchase in social equity.
For
I am asking simply, if you are purchasing the property from somebody else, how you will verify that property is in some disputes or in some contestants, or maybe some brothers would be there, sisters would be there in property, there would be there partitions for from so how you verify that? How you purchase in good faith?
as we purchased the land from Mr. Faizan Khan in the year 2023, we are having the proper documents
You are not having same date also.
because we are here to question the injunction. We are not here to oppose the possession of the land. We just wanted
How you will
discuss
ask
the
for
land.
free relief for injunction? First of all, you have to prove your title.
Your property belongs to you and
Yes.
Yeah.
what
Yeah, actually,
yeah,
the private facie is something like which the petitioner should provide because they have already
They already provided the registered will deed that shows that he is the owner or she is the owner of that property. So you have to disprove their title. Then only you will get injunction. Prima facie also, you should need to prove. You are not having just doing illegal construction on others' property. What? How to be give judgment of injunction? You have to prove something. You orally you are saying, okay, he is not got the title. So how you will disprove his title to the property?
we have just wanted to dismiss the injunction because we already are on the land and we have already started the construction.
If you are also person on anybody's land.
We already have the documentation.
So that we need now. That we need. We need documents, titles, sale deeds, verified from Mandal or some revenue department, something you should produce in the court.
Will attach the document in the annexures.
Okay, proceed.
Thank you, Your Honor.
Are you aware what you mean by encroachment? Because
Yes.
there is a charges on you that you have did illegal encroachment. Are you aware what is
Yes.
encroachment? What is that?
Encroachment is something where illegally construction of someone's land,
So
but
how you will prove that your construction is legal?
you already
How you will prove? Simple question. If somebody is charging you that you are doing illegal construction, then how you will prove that no, that is not illegal, that is legal construction? How you are going to prove that? Simple. Orally.
Yeah, it's true that we need to provide a registered document,
Yes.
which the defendant already had, but we'll provide after the annexures and attach it in the annexures later.
Because they are telling that if we will not provide them injunction, they will suffer an irreparable loss. And you are telling that no, if the injunction won't be given, then we are suffering an irreparable loss. Then what are the basis for our judgment? You have to provide as your case will be dismissed.
I understand, Your Honor, but for now, I will attach it in the annexures later.
Okay,
Proceed.
proceed.
Thank you, Your Honor. So, like, I just want to tell you that since petitioner's title is disputed, prima facie is not in his favor. Because developers already invested in a huge sum on the land, which they already got the title from the third party, and the balance of convenience title is in their favor. Because in section 41 of the Transfer of Property Act 1882, which states that transfer by ostensible owner, if Mr. Faizan Khan appeared to be the owner and developers purchased in good faith without notice of the defect, the sale is valid, which is against the petitioner. Which also says that the doctrine of acquiescence, equitable principle, where Mr. Petitioner delayed action until construction advanced suggesting acquiescence, which means already from the past, from more than the 4 months, we already started the construction, but Mr. Petitioner, with full knowledge, did not send any notice to us, but filed a petition stating that they want injunction on the said land. For temporary injunctions, mere proof of ownership is not enough. Plaintiff must prove prima facie case, balance of convenience, and irreparable injury. I would like to showcase the case law of K.K. Diwan versus District Judge Chandigarh, which held that the injunction cannot be granted when plaintiff has an alternative remedy, like possession or declaration. In my material page number 16, I would like to present an argument at once, which is may please the Honorable Court. The respondent, Nandan Developers Private Limited, respectfully submits that they are the lawful owner and possessor of survey number 153, Banjara Hills, Hyderabad, measuring 200 square yards, and seeks protection of his property rights against unlawful stopping the construction by the plaintiff. The following submissions are made in support. Section 151 Civil Procedure Code 1908, which says that which gives the court inherent powers to ensure justice and prevent abuse of process. These powers are not unlimited, but act as a safeguard where the court is silent. Thus, this honorable court is empowered where statutes are silent to intervene for equity, but never to act contrary to express provisions. In the page number 17, in my material, which says that ownership and title, section 101 of Indian Evidence Act 1982 states the burden of proof lies on the person asserting ownership. For page number 18 in my material, where it says that possession is not exclusive with the plaintiff, where section 110 of the Indian Evidence Act, possession presumes ownership unless rebutted. Here, developers are in open. Continuous possession through construction. Case law which supports the case is KK Verma versus Union of India, All India Report 1954, Supreme Court 191092, where it said that possession coupled with investment creates equity in favor of the possessor. I would like to call my co-counsel for the rest of the presentation. May I?
Yes.
That's all right.
May I go? In my material, page number 19. We got the safety and the permission from. Yes, I got the safety and the GHMC permission of using the material and access later before the final argument. And we will, as Your Honor asked about the permission, yes, we have taken the permission of GHMC. After verifying the GHMC inspector has issued the permission to construct, then we have to start with the construction. We will provide the safety and permission for the construction in annex. In my material, page number 19. Order 39. Rule 1. Case in which temporary injunction may be granted. The plaintiff is asking about the permanent and temporary injunction at a time lower court. So the lower court has dismissed his petition. The permanent injunction can be asked during after the hearing. The temporary injunction can be granted also after the hearing or on the day of the hearing. But perpetual injunction can be given after the hearing of the matter by evidences, by the witness statement, everything. For temporary injunction, I oppose and I request you to dismiss the petition as per the order 39, rule 1 and 2 of CPC Code 1963. I request my honor to refer page number 23. There is a will. Every property of all over India is done by the Transfer of Property Act 1882. Section 14 of sale deed validity. As you asked, madam, the validity of my sale deed. The sale deed would not be voidable where the defendant in good faith, as you about my good faith, as I am going to construct a developer, I am a developer, as I am going to construct a building. So the person who are middle class family, for them I can provide them in a low cost. That will be the good faith from my side to the middle class family. And for the sale consideration, the sale deed executed by attorney of plaintiff who was fully contempt to execute the sale deed in question. The IT Act came in 2000. After that, everything has came online. So I have verified the documents of Faizan Khan by embezzlement certificate from the Revenue Department. Incumbrance certificate from the Revenue Department. Then I have taken the certified copy from the Revenue Department before the Faizan Khan has the possession and the ownership from whom he has purchased. Yes, sir. I will provide you an answer. What are the questions which is right for my honorable judges? I am going to provide that. I request you to see the page number 23 in my material. The Transfer of Property Act, Section 5. I am already provided. Page number 21 in the book. Page number 21 of Transfer Property Act 1882, Section 5. Where I am in accordance with the provision of notice, sir. Provision of notice, section 6 notice, page number 21. In accordance with the provision of Transfer of Property Act, a person is said to have the notice of fact if of the following condition exists. When he actually knows that the fact, actually you know that the construction of building is going on from the 3 months. Will he give me written statement or oral statement. If he has given the oral statement, if there is a witness from your side that he have approached me, there is no witness because he has not given the oral statement. As he served me the notice that I am constructing illegal or encroaching the property or unlawful, no. As the section 5 of clause C, sir, when but for his gross negligence.
They have registered it. They have filed a complaint against the police station.
Yeah, yes.
So might at that time the police has called you and is taking care of it. Why you have taken?
They have legal remedy if they have pulled
So
up.
it means that he has informed you and of them, then only they can.
Sir, there is an oral and written statement. He can approach the police station. If police does not give the legal remedy, he can go for the private complaint in the court. Why did not approach to the private complaint?
But that all you know, it means
Yes, sir.
that all you know.
Yeah.
Because in the notice was given, then actually you know the fact. So
Fact.
but you are saying you don't know the fact.
Who's me? Yeah, I know the fact, sir. I know the fact that I am constructing the building which is registered safely and authorized owner of the property is Faizan Khan, and I am constructing only on the 200 square yards. If I am not a genuine person or the not rightful owner, then I will enclose the property of 800 square yards, not 200 square yards. As per my sale date, as per my position of the Faizan Khan, I am constructing just on the 200 only square yards. If I am not genuine, then if I am the encroacher person or unlawful person to trespass in property, then I can encroach the 800 square yards. Why only 200 square yards? It will be more benefited for me, monetary beneficial to me only. If I construct upon 800 square yards, why only 200 square yards? Because in the same deed I have got 200 square yards, so I am constructing and I have taken the permission from JMC. I will provide it answer. Answer section 6 clause C. When but for his gross negligence, he would have notice as per the Transfer of Property Act of two kinds. There is a notice of two kinds: actual and constructive. Actual notice, which is direct or express information or knowledge of the fact. Does he given direct expression information to me? Does he given any written statement, any FIR, any private complaint, or any letter in GHMC? Why GHMC can stop the encroachment property? It can stop, no sir. Does he give in GHMC? Greater Municipal Hyderabad Corporation? No. Only he is telling orally I did not police station. Show me the proof of police station, GHMC. You can approach the court for private complaint, but you directly file for the injunction. On this ground, lower court has seen and just dismiss the petition. And one more, sir. Constructive notice. There is a presumption that a person knows a particular fact. It may be under the following condition. Clause 3, sir. Registration. On a document being registered, it is presumed. On a document being registered, it is presumed that all person concerned have knowledge about the content of the document. If a document is registered in a government office, it is presumed that knowledge about the content of the document. I am not need to give the notice to my plaintiff opponent Ramesh Kumar, because the registered document is a public document. It is a public document. So in the clause of registration, I have the registration, I have done the sale deed, and section 14 says that the sale deed will not be whatever. The will deed can be what? And one more. 4. Actual possession. As it said that I am the actual possession, I am taking the taxation and everything. But the law of India that transfer of property in 1882 says that actual possession, when a person is in actual possession of a property, it would be presumed that he has a title on the property. As you have the title dispute 2023 and he has 22, I am the position, so I have considered for 3 months. So the law of transfer of property act says that when a person is in actual possession of the property, it is presumed that he has the title on the property. Simple. He has conveyed that. He has said that I am constructing for 3 months. Then what remedy has done in 3 months? Approach to police station. It takes 8 days, 10 days. Why not approach to GHMC, main authority of Hyderabad, to demolish illegal? And one more. Subclause 5. Notice to agent would be presumed to be notice to principal. I am the developer, I am the owner. I will be in my office. The construction time, they will be my manager or someone else. Why he did not inform to him? The law of property act says that notice to agent will be presumed to notice to principal. Does he said orally something to my agent? I have to, as per the law, I have to tell you. One more. As he approached the lower court and came to senior court, as a lower court above is senior court, above is this our appellate court, high court, and supreme court. But supreme court, sir, my material page number 20, sir. Dashi Man Susta and others for the Sriva Sudhira in view of outside finding, paragraph 16, paragraph 18 is very important, sir. Paragraph number 18, man. Say, my material 21. That the begin in the position, we are in full agreement with the view expressed by the High Court as well as by the trial court that the succession to the position of Madhadipati can only be done after the death of existing of Madhapati and not be before it. The part has noted herein in pursuit of the proclamation dated 12 December 1992 not be conclusively suggested that the respondent of the would have exercised all his power as gone to the match in favor of appellant number 1. Here the case was between the appellant number 1 and 2 and the opponents. So in paragraph number 6, 7, sir, in view of our discussion, is said by the appellant court. Para number 18. Para number 18, page number 21, sir. In view of our discussion, in my material. In view of our discussion, this discussion by the apex court, Supreme Court of India is giving a discussion that made hereby above in the view of admitted facts of all of the court. He has not presented any fact, but the apex court has said that admitted the fact of the court above stating from the trial court, while granting status quo during the pendency of the suit. Status quo during the pendency of the suit. It is pendency suit. Does by the injection before he has filed for the file in the court that my sale is unlawful. Does he file suit? Why does he not file the suit? That my sale deed, my construction is illegal. Just asking for direct temporary injection to corrupt me, to ask something from my side. One more that dated on September 2000, also judgment passed by the 4th Additional District Judge Tirupati in the suit, which is now under challenge and appeals, and also infirm judgment of the High Court. We are in senior court, but the Supreme Court has telling infirm judgment of the High Court and noted that the appellant number 2 failed to make out a prima facie case in his favor, and balance of convenience was also against him. According, we do not find any reason to interfere with the order of High Court in the exercise of our discretionary power under Article 136 of Constitution of India. The apex court has said he cannot come between the High Court matter, as the High Court is a lower from the Supreme Court. So how he can approach in the senior court? On what basis he has? There is a fact. In fact, we have presented. He asked about electricity bill, assessment, property tax. Does he submit that? Does he submit? No, he has not submitted. Yes, sir.
Utility bills they have submitted.
What is submitted, sir?
Utilities they have submitted.
Utility bill they have submitted. Okay, sir. Okay, my honor, you have said that I refer page number 14 of my material issue whether near position of the payment municipal used by the plaintiff confer in his principal right of ownership. Payment of property tax or electricity charges is only evidence of occupation, not conclusive proof of ownership. Ownership must flow from the legally enforceable title document. In the absence of conclusive proof of the title, the plaintiff cannot seek any injunction. If he provides the electricity bill and the bill of GHMC, it does not prove that it is a rightful owner, it is an occupation. Right? And in conclusion, it is humbly prayed in the honorable court may be please dismiss the suit of temporary injection. Direct the matter for the trial on merits. Let he have the trial. Why is not going to trial in the court? Let him have trial. I will stop the construction. Let them say I have a trial on the ownership document. Why going for the injunction? to have the to
Stop the construction if you are facing.
yes, let us they want irrevocable my monitor. Yes.
You can review.
Yeah. Award cost to be defended, pass any order, deem fit in the interest of the receipt, unless your honor has any further query, the also conclude the summation. I rest my case, your honor. And one more thing I want to I request from my side, section 41 clause G of section 1 clause G of specific relief act 1963, 41 clause G. I request to present the material to my honorable judges. 41 clause G of the specific review act, it is respectfully submitted that as per the section 41 clause G, an injunction cannot be granted to prevent a continuous breach in which the petitioner exercised. In the present case, the petitioner silence during the initial construction period to the accusations. As initial period he was silent. The article I am talking from the law, legal provisions. Does he coming from that? Does he have? No. Section 41 clause yes, sir. I request to refer that. Specifically, furthermore, your honor, section 41 clause the past injection and equally leave can be obtained by other usual modes of proceeding. Monetary compensation would be adequate remedy in this case. Monetary, because he has filed a temporary condition. I respect the court, and I have stopped the construction while he filed the right. I respect the court. The court has disciplined my plea. Then he claimed the senior civil court, but also I have stopped because I want to know that if the senior civil court give the judgment in my favor, then I will start the construction. And you asked about the good faith, the middle class family are suffering. I will provide my developer many flats in low cost to them with less margin of profit. It will be the good faith of our community and society. I am constructing on 200, not 800. If I am the unlawful encourage, I can approach 800 square. We approach police station, JHMC. Does he have any complaint orally or statement? If he don't orally, let the police officer come and say he has approached let the SI come, let the sub inspector come, let the return officer. Yes, sir. Yeah. I am asking for that, sir. I am asking for the trial because in the trial, in the trial he cannot go. And memorandum of my sales deed, I request to present. Sales deed has been provided. Thank you.
Yeah, please be seated.
Thank you.
We will now pause for a 5-minute break to allow our respected judges to evaluate performance.
I want to do that. And I will take 5 minutes here.
Okay.
They will be counter. This is an order. Will be counter.
Respondents, your memorial to the bench.